The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Morning. Our next case is State versus Chavez, and we'll hear from the appellant.
Thank you. Good morning, and may it please the court. Asher Spiller on behalf of the state. I'd like to reserve 8 minutes for rebuttal. This court held nearly 40 years ago in State v. Odom and reestablished 10 years ago in State v. Lawrence that to prevail under the plain error standard, a defendant must show that the trial court's error had a probable impact on the jury's finding of guilt. In this case, the Court of Appeals violated these precedents by holding that the trial court's instructional error automatically entitled defendant to a new trial, regardless of whether the error had any impact on the jury's verdict. At defendant's trial, the state presented overwhelming evidence that defendant and Carlos Manzanares conspired to brutally murder Roberto Martinez. If the trial court had identified Carlos as defendant's co-conspirator by name in the jury instructions, the outcome in this case would not have been any different. We therefore request that the court uphold defendant's conviction for conspiracy to commit murder. And I'd like to make 3 main points today. First, this court's precedents have expressly rejected the per se prejudice standard adopted by the Court of Appeals in this case. Second, the evidence against defendant in this case was overwhelming, such that there is not a reasonable probability that the jury would have reached a different verdict if no instructional error had occurred. And finally, the Court of Appeals decision should be reversed for the independent reason the defendant invited the error that she now raises on appeal. In State v. Lawrence, this court stated that its decision was meant to, quote, clarify how plain error review applies to unpreserved error in criminal cases. In other words, in Lawrence, this court was providing a roadmap for how plain error review is to be conducted in cases just like this one. The court held that under the plain error standard, the defendant must show that the trial court's error had a probable impact on the jury's finding, meaning that if the error had not occurred, the jury probably would have reached a different verdict. In Lawrence, the court held that because and where the state presents overwhelming evidence supporting the conviction, there is no plain error. After Lawrence, this court has issued a series of opinions reversing Court of Appeals cases where the Court of Appeals failed to conduct a proper prejudice analysis. And one of those cases is particularly relevant here in that State v. Boyd, where the trial court erroneously instructed the jury on a removal theory of kidnapping, which was not alleged in the indictment. And the Court of Appeals held that defendant was entitled to a new trial regardless of the evidence of defendant's guilt, just as occurred here. Judge Stroud in the Court of Appeals dissented in that case, and in her dissent, she applied the roadmap that this court established in Lawrence and Odom, and concluded that because there was overwhelming evidence of defendant's guilt in that case, there simply was no plain error. And on appeal, this court reversed and adopted Judge Stroud's reasoning, thereby rejecting the per se prejudice standard that had been applied by the panel majority. And in this case, the Court of Appeals made the very same mistake that the court made in Boyd by failing to apply the Lawrence prejudice standard and instead improperly relying on language from this court's decision in State v. Tucker. And this court has explained how to properly read State v. Tucker. The court addressed that issue in State v. Gainey. And in Gainey, as in Boyd, that was also a case where the trial court erroneously instructed the jury on a theory of kidnapping not alleged in the indictment. And the court held, applying the plain error analysis in Odom, said that given the strength of the evidence presented at trial, there was the instructional error didn't have a probable impact on the jury's finding of guilt. And in reaching that conclusion in Gainey, the court rejected the very same interpretation of Tucker that the defendant and the Court of Appeals put forward in this case. The court explained that Tucker does not relieve the court of its obligation to conduct a prejudice analysis, and that in Tucker, the court in fact did conduct a prejudice analysis and found only plain error due to the highly conflicting evidence of defendant's guilt in that case. But another case where this court has rejected the prejudice per se approach was State v. Malachi, where the defendant actually properly preserved the issue for appeal. And this court held that even where the issue is preserved for appeal, the defendant still has to show prejudice. So the standard that was applied by the court in this case was less onerous than even the standard that gets applied if defendant preserves the error for appeal. In Malachi, the court also explained that it addressed circumstances where an automatic reversal or per se prejudice rule might be appropriate. And the court said that that standard shouldn't even be applied in cases where an instructional error arises in the context of multiple theories of guilt. In other words, the case we have here. And I'll just move along to the evidence that was presented in this case, which I think shows that the evidence of defendant's conspiracy with Carlos was overwhelming. This court has recognized it's the rare case where you have direct evidence of a conspiracy, but that's what we have here. We have both direct and indirect evidence. The state's evidence showed that at 2 a.m. in the morning, defendant and Carlos and another man stormed into Roberto's bedroom at the same time while Roberto was sleeping with Maria and her baby. And when defendant shouted, "I'm here to kill you," and threw a machete at Roberto, Carlos immediately proceeded to attack Roberto with a hammer and a machete and beat him unconscious and left him with lasting neurological damage. And later, when defendant shifted her attack towards Maria and her baby, Carlos intervened, saying, "You told me we were here for something different." In other words, referring to their prior agreement to kill Roberto. The state's evidence also showed that while he had reservations about the assault on Maria and her baby, Carlos agreed to let defendant kill Maria if it was discovered that Maria had called the police to report their assault on Roberto. It's truly a rare case where the state has stronger evidence of a conspiracy than in this case. And it's simply not probable that if Carlos Manzanares had been mentioned by name in the jury instructions, the jury would have reached a different verdict. So just to summarize, this testimony introduced by the state in this case was uncontroverted and overwhelming, and therefore we think no plain error occurred. Just turning to my final point, the Court of Appeals decision should also be reversed for the independent reason that defendant invited the error that she now raises on appeal. This isn't a mere case of defendant failing to object. I think reviewing the trial transcript in this case, this is a case where the defendant actively participated in formulation of the jury instruction. The trial court repeatedly and diligently sought defendant's assurance that defendant had no concerns with the instruction, and the defendant's responses led the court to believe that defendant was satisfied with those instructions. Did
Mr. Spiller, just to make sure I understand the record, and it's always okay to tell me that I don't understand it correctly, that's why I'm asking the question. Did the defendant affirmatively do anything to cause the trial court to use the defendant in more than one other, at least one other person, conspiracy instruction?
So the defendant certainly requested supplementation of the conspiracy instruction with the addition of the mere presence instruction. And then after the trial court repeatedly asked defendant if he was satisfied, if he had any questions, concerns, comments, objections, the defendant indicated that he had no concerns, corrections, or objections. So I think
just to follow up on that a second, to make sure that I understand your argument, is the state's position then that if the trial court affirmatively asks the defendant, do you have any objections, and the defendant says no, that by itself results in invited error?
I don't think we'd go that far, Your Honor, but I think on this record, this is more than just the defendant stating he has no objections. This is a case where the trial court and the defendant had a robust exchange where the defendant was asked to review the instructions as written. The defendant asked for a supplement to those instructions, which was allowed, and the defendant indicated he had no corrections, comments, or objections. So I think this goes beyond just a mere case of the defendant saying no objection.
Okay, thank you. But I do take it that your principal argument is, one, this is a plain error case, and secondly, that there's no plain error here.
I would say so, Your Honor. I think the plain error issue is the far clearer issue, just due to the overwhelming evidence of defendant's guilt in this case and the clear precedents from this court.
Thank you.
Where do we draw the line between plain error and invited error when a defendant does have some input into the jury instructions?
How does the court draw that line?
Yes.
So I think there are a couple of cases that are instructive here. One is State v. Gainey, where the defendant did not, excuse me, I'm sorry, the trial court issued in sentencing form to the jury, and one of the possible punishments was life imprisonment rather than life imprisonment without parole. And the court stated in that case that defendant specifically told the trial court that he had no problems with the form. And the court held that to the extent the defendant agreed with the trial court's manner of instruction, the defendant has invited any alleged error. So I think in our view, the court should conduct an analysis of the record and determine whether the defendant has indicated that he's satisfied with and has consented to the instruction as given.
So does consent equal invited error, even though the defendant may not actively have any input beyond just a response to the trial court's inquiry as to acceptance?
I think that on this record, where the defendant is actively participating in formulating the instruction, reviewing the pattern instruction as given, and then asking that instruction to be supplemented, as he did here with the mere presence instruction. I think on those facts, under this court's precedent, there would be invited error.
But just to follow up, to be clear, the plain error argument is dispositive, right? We don't necessarily need to reach the question of whether there was invited error here if we agree with you that there was no plain error.
I agree with that, Your Honor. So unless there are further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel. We'll hear from the appellee.
May it please the court. My name is Marilyn Ozer. I practice in Orange County, and I'm here this morning representing the appellee, Fabiola Chavez. I know that we've just been dealing with whether or not it's plain error, but it seems to me to be particularly important that we understand exactly what the error was in this case. All instructional errors are not created equal. They are different. And this one is particularly grave. North Carolina Constitution, Article 1, Section 23, guarantees every defendant will be notified of the charges against him. This was violated in this case, which differs from all of the cases that the state has cited. The purpose of this provision is so that the defendant can have a fair and reasonable opportunity to prepare his defense. And by naming one co-defendant and not the other, even though the state must have known from the very beginning there were two men, not one, there was no reason for the defendant to prepare to defend a conspiracy charge against the other man. And that's what happened. So this is a violation of the North Carolina Constitution, which differs from the cases the state has put before you.
Ms. Ozer, let me ask you one sort of basic question that I don't know the answer to and would like some enlightenment on. Is there a requirement in our statutes that, or case law, that requires that every participant in a conspiracy be identified in the indictment?
It's not in the statute, it's in the Section 23 of Article 1.
Can you cite me a case that says that every participant in the conspiracy needs to be set out in the indictment?
Well, back in 1935, almost 100 years ago, this court issued an opinion in Mickey in which there were two co-defendants named, two co-conspirators named in the indictment. And when it came time to charge the jury, the judge said, it can be either this man or that man or someone else or all of them. And what this court held back then was that that was fundamental error because the defendant had not been prepared to defend against other people when two of the men had been named in the indictment. That's been the law in our state for almost 100 years. There's no case that has overruled it. And I'm sorry, does that answer your question, Justice?
Yes, ma'am. I was trying to see what authority you could cite me, if anything, and you've cited me, Mickey, and I've got a copy of it right here, so I'll take another look. Thank you.
So moving on to the state's cases, and I went into how fundamental this was so that it's easy to understand why the state's cases don't apply. In State v. Lawrence, which is the case cited in the reply in the state's briefs, what happened was the defendant was charged with possession, armed robbery. And the jury instruction on the armed robbery was correct. It was robbery with a dangerous weapon. But when they got to the conspiracy charge, the dangerous weapon was omitted. And this court found that that was harmless error because the jury had been instructed on the correct elements in the underlying charge, and the defendant, as opposed to this case in which she had no reason to defend against the other man that was involved. In Lawrence, the defendant knew exactly what the charge was. It was armed robbery with a dangerous weapon. So it was not in violation of the constitutional provision that you have notice of what the charge is against you. In State v. Boyd, that was mentioned this morning, it was a fairly gruesome kidnapping charge in which a woman was held in her apartment for hours while a man she was trying to talk the man out of raping her and assaulting her. And they moved around from one position to another position. And the question was whether adding the word removal to the jury instruction was plain error or harmless error. And what the court found was no, there was plenty of evidence of all the elements of kidnapping in this hours-long assault on the woman. And that if the word removal had not been in the jury instruction, the jurors would have come to the same conclusion because of all of the evidence of what had happened that night. Similarly, Gainey, also mentioned this morning, is another kidnapping charge. And that one is even more specific because what the indictments said about kidnapping was that the victim was confined. But when they got to the jury instruction, they used the word restrain. And there's a long passage in the opinion about whether confine and restrain mean the same thing. Again, it differs very much from Fabiola Chavez's case because clearly the defendant in both Gainey and Boyd knew they were defending against kidnapping. And they needed to prepare a case against any theory the state would come up with. You know, there's some charges such as first-degree murder in which the state does not even need to say what its theory is until you get to the sentencing charge. But in any case, in both Gainey and Boyd, the defendants were told what the charge was against them. And the question is a word or two in the jury instruction. And the court finds that there's no error. State v. Maliki is a case, another case. This one is about constructive possession versus actual possession. The defendant was at a gas station. Someone had called the police and said, there's someone in this gas station who I just saw stick a gun in his belt and his pants. And the police arrive, they find the guy that looks like the 911 call and start to arrest him. And sure enough, they get the gun out of his belt. So the question that arises in Malachi's trial is whether it was error to say constructive possession when there was actual possession. The gun's in his belt, they get it. So constructive shouldn't have been instructed because there was no evidence, it was just instructive. But again, this differs from Fabiola Chavez's case because the defendant in Malachi knew he was defending against possession and he could prepare a case against possession. His constitutional right to be informed of the charge against him was not violated. And that's what happened in this case. So it's very important, and why I'm emphasizing what the error was in this case, is that it differs from all these cases where they're using different words, theories for kidnapping, or constructive versus actual. Those defendants have all been informed of the charge against them, and they have prepared against it. Now, the state has also ended with a question of invited error versus plain error. And as is shown in the opinion below, the attorney didn't ask for anything to do with the conspiracy charge. His only request dealt with acting in concert. And when he's asked, do you agree with the acting in concert instruction? He says, yes. But we can't make it invited error if an attorney asks for something in a different charge that you're not questioning, because then anytime an attorney asks for a specific instruction, it's invited error for every other instruction. I mean, that just isn't going to work. What the judge said, and this is on page 377 of the transcript, the way the acting in concert was put in there under the first-degree murder charge, is that okay with you? And the defense attorney says, yes, sir. So what he's agreeing to is the acting in concert instruction. And in the opinion below, they deal explicitly with the state's assertion that asking for any instruction, if you agree to instructions as a whole, then it's invited error. The court below, Court of Appeals, cites to State v. Hooks, 353 NC 629 at 633 from 2001, and State v. Hardy, 353 NC 122 at 131. This court said, even though the defendant had ample opportunity to object to the instruction outside the presence of the jury, after excusing the jury to the deliberation room, the trial court asked, prior to sending back the verdict sheets, does the state wish to point out any errors or omissions from the charge? Trial court then asked that of the defendant. Defendant responded with respect to other issues, but did not object to the instruction in question. That's State v. Hardy, and they do not find invited error. So the precedent in this court is that it's not invited error if you object, if you agree to the instructions as a whole.
Are you suggesting that we should begin to have trial courts and we appellate courts to not look at jury instructions any longer as a whole, but instead to look at them in segments as to whether or not there is error, particularly invited error?
Justice Morgan, I'm sorry, I might have been confusing. That's the opposite of what I believe, because what the Court of Appeals did in this case was look at the jury charge as a whole to see if the error had been rescued, and they found no. Looking at the jury charge as a whole, it had not been rescued. And what I'm suggesting is that this court not find invited error because the defendant asked for an instruction on a different charge. In this case, the instruction went to attempted first degree murder, not to conspiracy to commit first degree murder. So what I'm asking is that this court not establish a holding that if you ask for an instruction in one of the charges, it's invited error if you don't object to the other charges. I'm sorry, you look like I'm confusing you.
I'm working it out. Thank you.
I'm sorry. And going back to the strength of the evidence against Carlos, I disagree strongly with the state's view of the evidence that Carlos was a co-conspirator in first degree murder in the jury's point of view, because Carlos turns out to be a hero in this case. When Ms. Chavez starts to attack Maria, what he does is he restrains Ms. Chavez. He keeps her from hurting her. And the defense, because it has prepared against the conspiracy for Carlos, presents evidence that he was not the conspirator. The defense attorney asks, "What did the guy in the yellow shirt do?" Maria answers, "He grabbed Chavez, detained her. And he told me, 'Grab your child and leave, get out of here.'" Defense attorney then asked Maria, "So did he save you?" And she responded, "Yes, he saved me." That's transcript page 247. The defense attorney then asked, "What about the man with the yellow shirt? What did he do? Did he leave?" And Maria responded, "No, he stayed there with me. And he said as long as he was there, he wasn't going to let anything happen to me." Did he stay until the police arrived? Yes. Transcript page 258. So clearly, defense attorney had prepared to defend against Carlos as being a co-conspirator. And a lot of it's reasonable to believe that the jurors are going to see this man as a hero. He saves Maria's life. She says he saved her life. And he stood there to protect her, knowing he was going to be arrested until the police came. Now you have to look at this in juxtaposition to what the other man did, who is not named in the indictment. And even though the state seems to think it's Carlos that was hitting the male victim, Roberto, with the machete, what Maria testifies to is that they were both doing things. She does not pick out one of them as far as Roberto is concerned. But the other unnamed man runs out of the apartment with the machete, runs away, doesn't try to protect anybody. He's got the machete. If anyone's a conspirator, it's the one with the machete, but he's not named.
Ms. Ozer, does it matter that the indictment for conspiracy to commit murder alleges that the conspiracy was directed toward both Roberto and Maria?
The indictment against Maria, the indictment was changed before the trial began.
I'm sorry.
To take out Maria.
Right. So the indictment that was the indictment that underlay the defendant's conviction alleged a conspiracy to murder Roberto.
Correct.
Does it matter that does the fact that Roberto is identified as the victim matter for purposes of this prejudice analysis, however we will describe it?
In my opinion, the jury that would have seen Carlos as a hero would have been less likely to see him as a co-conspirator. The state also quoted from the transcript that Carlos says, "This isn't what I intended." And the state then conjectures that what he meant was he did not intend that Maria be a victim. But we don't know that. We don't know what he didn't intend, and the jury didn't either. And attached to the appellee brief in the appendix, I have a news release from the district attorney's office in Mecklenburg, which states that after Carlos Manzanares was tried, the jury deadlocked. There was a mistrial. So the jury that was just looking at Carlos as being attempted murder, conspiring with Fabiola Chavez, could not reach a verdict. So as much as the state wants to say the evidence in this case was so strong against Carlos, when Carlos was tried by himself, the jury could not find that, which I don't know how anything the state says is conjecture as far as what they would have done in this case. We know when a jury specifically looked at Carlos, they did not convict him of either the underlying offense or the conspiracy. If the court doesn't have any other questions, I'd ask this court to affirm the Court of Appeals decision. It's very well thought out, and I think answers most of the questions this court has had this morning. Thank you.
Thank you, counsel. Rebuttal.
Yes, thank you, Your Honor. Just a few points. Touching on what counsel mentioned towards the end of her argument, the deadlock in the case against Carlos. I have no idea what the evidence was in that case. What I do know is that the evidence in this case was overwhelming. And Justice Ervin, as your question was getting to, whether or not Carlos protected Maria is entirely irrelevant to whether there was a conspiracy to murder Roberto. In this case, Maria and Carlos showed up at the same time. Maria declared, "I'm here to kill you," and Carlos immediately proceeded to attack Roberto. Later, Carlos says to Maria, says to defendant, "You said we were here for something different." Right after he beat Roberto unconscious with a machete and a hammer. The evidence of the conspiracy in this case was truly overwhelming. The other point I want to address is counsel's claim that the error in this case was so significant or so strong because it raised some sort of a constitutional issue. This case held in State v. Walker and other cases that even where the error at trial affects a fundamental right, the plain error analysis still has to be conducted. And there's no dispute in this case that the plain error analysis is what applies here. And under the plain error analysis, as this court's precedents made clear, the court has to evaluate the strength of the evidence against defendant and determine that if the error hadn't occurred, whether the jury would have been likely to reach a different verdict. The other point I want to address is the comparison of the evidence between the unidentified person who was there and then left and Carlos. The state was very clear in this case as to what its theory of the case was. At closing argument, the state said to the jury, "You have to find that the defendant and at least one other person entered into an agreement. In this case, that's Carlos Manzanares, the guy in the yellow shirt, and that agreement was to commit murder." And then later, the state's counsel repeated again, "Defendant is guilty of conspiring to commit first-degree murder. She formed an agreement with at least one other person, that guy," pointing to an image of Carlos Manzanares on the screen to kill Roberto. This is not a case where the jury didn't understand what conspiracy it was tasked with finding. And then briefly to address State v. Mickey.
About your the last thing you were discussing about the that Carlos was identified in the presentation to the jury. As I understand Ms. Oser's argument, she's saying that not having the person named in the indictment gave inadequate notice under provisions of the Constitution. What do you say about that?
So we're not arguing in this case that it wasn't, this court's precedents do make clear that if the indictment specifies a particular defendant, then it's error for the jury instruction to not specify that defendant. The question is whether it's plain error, whether that deviation from the indictment is so significant that if it had been cured, the jury would have reached a different result. And what this court has said over and over again is that the court has to evaluate the strength of the evidence against defendant, and where it's overwhelming, there wasn't a plain error. And in Gainey, I'm not sure I heard why Gainey or Boyd, either of those cases are distinguishable. Both of those cases deal with circumstances where the jury instruction departs from the indictment and alleges additional elements than what was specified in the indictment. And the court held that in that case, you have to do a prejudice analysis, and you have to determine whether the strength of the evidence against defendant was such that had the error been corrected, the jury would have reached a different verdict.
I guess the question goes more to what significance, if any, does the state put on the lack of notification in the indictment of the identity of the other person, as whether that's a fundamental error or not, which is, as I understand it, what has to be shown for plain error.
Yeah, so it's certainly not. So under the plain error standard, there both has to be an error, and then there also has to be prejudice. And our argument is, regardless of whether there was an error in terms of the deviation of the jury instruction from what was alleged in the indictment, it was not prejudicial error. The defendant was on notice that the state's charge was conspiracy, and the evidence presented by the state was overwhelming evidence of a conspiracy with Carlos. And so we don't think that even if the jury instruction had identified Carlos specifically as the co-conspirator, the jury would have been likely to reach a different verdict, which is what this court's precedents require for plain error to occur. And then just briefly addressing State v. Mickey, that case was decided in, I believe it was 1935, long before this court articulated the plain error standard in Odom, and the court made no mention of what standard it was applying, whether the error had been preserved for appellate review.
Isn't it a matter of historical record that up until the adoption of Rule 10b-2 in 1981, that no contemporaneous objection in trial court was required to preserve challenges to trial court's jury instruction?
Yeah, I'm not familiar exactly with the history of the standard of review. That may be correct, Your Honor. I just know that it certainly was long before this court articulated the plain error standard as it did in State v. Odom, and then as it reestablished in State v. Lawrence. So unless there are further questions, we would respectfully ask that the court reverse the Court of Appeals and uphold defendant's conviction for conspiracy to commit murder.
Thank you, counsel. Thank you, everyone. Madam Clerk.
Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now in recess. God save the state and this honorable court.